Class actions are so powerful because the numbers get so big so fast. And what I mean by that are the number of clients and the number of dollars that a defendant has to deal with. So for example, a corporation who manufactures a car or a device or emits pollution, there are a lot of people that are affected by that, a lot of dollars that are at stake in those lawsuits. And as a result, judges pay a lot more attention to those cases. And when you combine a large number of people with a lot of money and a judge that's paying attention to the case, you can bring about powerful changes. Class actions do require specialized attorneys. Class actions typically involve cases where the stakes are very high, and as a result, the companies that are sued, called defendants, typically hire some of the best attorneys in the country. Also, the judges look at those cases a little different than the run-of-the-mill lawsuit. Because the stakes are so high, the judges demand a higher caliber work product. And so in a class action lawsuit, you typically have some of the best lawyers that specialize in that field. And if you are in a class action or have a case that can be certified as a class action, you're going to need a specialized attorney who regularly handles and wins those cases. Certain types of cases make for good class actions, and the types of cases that we're talking about are where the evidence or the facts are basically the same for all of the people involved. Some examples would be a defective car or a defective product. Everybody who bought that product basically has the same case, and so they're going to use the same evidence, the same witnesses, the same documents to prove their case. Another example would be a wage and hour case where people aren't paid overtime. If you're not being paid overtime, it's likely that your co-employees are also not being paid overtime. A third example is called an antitrust case or an anti-competitive case where a couple businesses conspire to rig the market or price fix, have a monopoly of some sort. Well, everybody who's affected by that in the marketplace is essentially laboring under the same problems. Again, they're going to have the same evidence, same witnesses. The legal term that describes all that is called commonality, and in the class action world, that's the test for a class action. Cases that have commonality are good class actions. Class actions accomplish efficiency, and that's really what they're all about. You can look at a class action and its efficiency from three perspectives, really. From the class, the people who are in the case, from the courts, and from the defendant's perspective. So from the class's perspective, if you have 5,000 people who have been harmed or alleged to have been harmed by a product or some type of an event that applies to all of them, they don't have to all hire a lawyer. They don't have to all take off time from work and go to court. There's 2, 3, maybe 7 of them that are the class representatives, and they prosecute the case with the lawyers. From the defendant's standpoint, it's equally as efficient if it's all wrapped up in a class action because they don't have to sit down for a deposition and put their people through court hearings, produce documents 5,000 separate times. They do it once. And from the court's perspective, they're very efficient. Again, if you have 5,000 lawsuits that essentially involve the same facts and circumstances, and you have them all going through the same courthouse, the court will grind to a halt. And so efficiency is really what a class action is all about. Not all cases make for good class actions. For example, a case where we had individual reactions, individual circumstances, something unique about the parties, those don't make for good class actions because the evidence and witnesses that will be used to resolve that case are different. It's not the same for everybody. And that is what was required for a class action. And if you think about it, when a judge or a jury resolves a case and it's certified as a class action, that decision will be binding on all of the class members. And that would include the absent class members, the people that aren't actually in the courtroom. And if those people have unique facts and circumstances, different reactions to the product, or different legal issues and defenses, different meaning different from the named class representatives, then it's just not fair to have them bound by a proceeding. They should be able to go get their own lawyer and decide if they want to resolve that dispute. So a case that has unique facts and circumstances is typically not certified as a class action. And it really comes down to what in constitutional law terms we call due process. We don't deprive people of life, liberty, and property without due process. That means those people have the chance to come in and have their own case heard in front of their own jury. There are some differences between class actions in federal court versus state court, and it essentially comes down to the rule that governs the class action. In federal court, there's one rule, it's called Rule 23, and that's the court rule that allows for class actions, and it determines the criteria that one must have to become a class action. The states all have similar rules. They're not exactly the same, and they vary from state to state. However, in 1994, 1995, Congress passed a law called CAFA, stands for the Class Action Fairness Act. And when Congress passed this law, they essentially said, we think class actions should all be in one court system. There were some states that were anti-class action, there were some states that were very pro-class action. And so you had a body of law that really kind of developed different from state to state, and it was affecting the rights of the parties depending upon where those cases were filed. And so by kind of centralizing the courts where class actions basically were held into the federal court system, Congress recognized that uniformity was good. Uniformity in these cases and how they would be certified, how they would be processed was good. Because Congress knows, as do the courts that handle these cases and the lawyers that work in this field, that class actions can be very powerful cases. They're very important cases. And so today, there's not a whole lot of difference between a federal class action and a state class action due to the fact that probably 80 to 85% of class actions all are in federal court. There are many considerations that one must think about before deciding whether or not to pursue the case as a class action, and we review those with all of our clients. What it essentially comes down to is whether the extension of time, because lawsuits take a long time anyways, and class action lawsuits generally take longer, whether that extension of time is worth it. And on the other side of the aisle are the benefits that a class action brings. There's more money at stake, there's more people at stake, there's more attention, the courts give them much more attention. And so when we counsel our clients, we look at their individual facts and circumstances. We decide if there's a strong likelihood that the case could be brought as a class action, and we let them know about all of the benefits that are available if the case is certified as a class action. And in many instances, we find that a class action is the better path to go. In some instances, it's just not. And in those instances, we pursue our individual client cases as individual lawsuits.